Hello, 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 and welcome everybody. How is everybody today? Okay, so I don't know why my... Okay, let me just see if this is up. Good morning, Nana. Can you guys all see my screen? I'm coming up blank on my... I may have to reset. Let me just see here if I can share this. If not, you guys, I will have to reset. Okay, you guys see the wings? Okay, because I'm not seeing it up on my live in my studio, so it's not working properly yet again. Go figure. So can you guys all see the paperwork that's up? You'll see the document? Okay, let me get out of studio and come back in. Just give me a second here. I'm not going nowhere from StreamYards. I'm just going to try and load my YouTube studio so I can see the chat and stuff. Sorry, you guys. Good morning. Oh, there we go. Okay, I got my studio working. Now I can see chat. Okay, so I did put it for subscribers only. That's not the same as memberships. You don't have to pay to subscribe. Subscribing to the channel is free. I put it that way, you guys, just to try and maybe keep the trolls down a bit. Hello, Beach Bum. Glad you guys can see everything. Okay. Bonnie Baker, good morning. Good afternoon almost here. Diane, good morning. Marie, good morning, my love. Jean P, good morning. Good to see you guys too. So I got a bunch of new stuff in the Vallow Daybell case. We've got some things here that were newly filed in response to what Chad Daybell's circus monkeys are trying to do and what Lori Vallow's circus monkeys are trying to do. And we're going to go over it all. I'm going to ask you guys, please smash that like button. Get us out there in the algorithm so we can get going on this. It's free also to smash that like button. Got 30 people in here and only 13 likes. Help us get it out there so we don't have to continue to stop throughout this to update people on what's going on. And it shows some support for the channel, so I appreciate that very, very much. So I hope everybody had a great, I know in the States it was a holiday weekend. Hope you guys all had a great holiday weekend. Now I have been watching, while we're waiting for everybody to do their likes and whatnot, let me just check the updated files here to see if there's anything new in the Idaho 4 case. And there's not. There's just the last thing that was filed was the request for discovery, and we've already gone over that. Let me just check the Vallow Daybells just to make sure I've got everything here. See if anything was maybe recently filed this morning. I think they're only a couple hours behind us. They seem to put things into the record early in the mornings. Nothing new in Chad's except for what I've got. That was just filed. Okay. Let me just make sure I've got this. Okay. I've got everything that's in this case already. Now, these were just filed late Friday. I wanted to try and do it on Saturday. Saturday ended up into a cluster, you know what. Didn't have the time to get back home and do this in time. So Sunday, I paid for what I did Friday with eating pizza. I'm gluten intolerant. It was a shit show. literally. So I couldn't do my live for you guys for your mini reads on Sunday, so I did that yesterday, and here I am today feeling 100% again. So here we are. So let's go over this, you guys. We'll start with some of the quick stuff. This is only a 2-pager. Under your scars, hello. Hello, great to see you guys here. So the defense had filed a motion wanting all the grand jury transcripts, yada, yada, yada. So this is what the judge did give them. Based on the defendant's motion, and this is only for Chad Daybell, for the grand jury transcript, which was argued on October 13th, 2022, the court granted the motion and entered an order on October 17th, 2022 to authorize the court reporter to prepare the transcript. On January 10th, the court received and reviewed the transcript pursuant to the October 17th order. Accordingly, the court hereby authorizes the transcript to be delivered to counsel for the parties in this matter. So this was ordered on the 11th. It didn't hit the file, you guys, until Friday, late Friday. Hello, Chatter. Good morning. Yes, I am feeling a lot better. It was self-inflicted. I know better than to eat anything with gluten in it. So that we're going to get through the quick stuff first. There's one here, the next one. This is the objection from the prosecution because the defense is wanting to continue the case again. As we know, there's been 3 trial dates set for this to get underway. Each time, Chad's circus monkeys have decided that they still don't have enough time, and they keep continuing the trial. Now, it was supposed to have already started on January 9th. It was continued again because of Chad Daybell. Lori wasn't competent again, blah, yada, yada. So it was moved, and now the affirmative date is April 3rd. So the defense has filed a motion now that they want to continue it until late October, maybe even into 2024. Now, as the prosecution, and I totally agree here, I think they've been given enough. They've been given a lot of leeway, like especially with the amount of stuff that has to happen in Ada County for this to go to Ada County and what they've got to get set up to be able to accomplish that. Now it's all put on the back burner again. So there's more taxpayer money wasted with whatever, contracts they sign for security and stuff like that. That's still got to be paid. Now they're going to have to pay it again because they've canceled the date. It's a cluster F. So now the prosecution is finally getting mad. Hello, Summer Dawn. Thank you for being here. So if you remember correctly, and I do believe it says it in here somewhere, we're going to read through this. I'm going to skip through a lot of the history jargon and stuff because we already know about that. But you can see what Chad Daybell's circus monkeys are trying to do. They're trying to get this trial separated, okay? And it's not working. They've asked for the trial to be severed. It's not working. So now you've got Chad Daybell, who has waived his right to a speedy trial. You've got Lori Vallow, who has not waived her right to a speedy trial. Something's got to give somewhere, and I think they're trying to set this up for something to happen in the end. That's what I feel, that they're setting up excuses to say that the trial wasn't fair or for an appeal or whatever they're doing. Because as far as Lori Vallow, by law, they should have had her in trial by October because she did not waive her right to a speedy trial. Now, that was only put out to January, and they said because of the volume of evidence and this and that, it wasn't too far-fetched to do that, really didn't impede on her right to a speedy trial. So they didn't fight it, they didn't argue it, but now it's been put out to April, which is you're getting pretty close to almost a year past the date that she was entitled to her speedy trial. So far, I haven't heard nothing from the other circus monkeys complaining that it's been put out to April because She kind of ended up back in the hospital for a little bit, but she was out in time to go through with the January 9th, but that had already been changed to April 3rd. So, okay, it gives us a little bit more time. But now with this, with Chad Circus Monkeys wanting this moved out even further now there's going to be a problem because Lori Vallow wants her speedy trial. And if they put this off again, she's going to have a good reason on appeal to have her charges thrown out. Or they could also petition the court to have all charges thrown out because they've not brought her to trial in a speedy manner and she has not waived her right to a speedy trial and they're getting fed up. They want it thrown out now. There's a lot of possibilities that can happen here. There's a lot of juggling that has to go on to make sure everybody's rights are being, looked at and everybody has their fair rights, right? So if they move it now from April 3rd, I have a funny feeling that Lori Vallow Circus Monkeys are going to file for a complete dismissal. Now, what else we got to go over here is if you guys remember when they first set a trial date for January 9th, Chad Circus Monkey was standing up. No. We're ready to go. Blah, blah, blah. We'll be ready to go for, even earlier. Okay, we'll take the January 9th. Okay. They actually had asked for a trial in October. So then saying that, okay, they're going to be ready for January 9th. Let's go ahead with the January 9th. Then they put that off to April 3rd. And now they're saying, oh, well, now we can't be ready. It's like, it's a three-ring circus. One hand doesn't know what the other one is doing. It's like, look at John Pryor. You said you wanted this date. You got it. And this is going to be the second time now he's tried to put it off. And I think the court is going to deny this. So let's go over what the DA is now saying regarding this, because Chad Circus Monkeys have now filed a motion to continue it. They don't want it now until the end of this year in the fall or next year. So the state of Idaho, by and through Fremont County Prosecuting Attorney's Office, submits the following objection to the defendant's motion for a continuance, which is another one. Okay. The defendant, and here we go here. The defendant had his initial appearance on May 26, 2021. The defendant was then arraigned in the district court on June 9th, 2021, and the state announced its intent to seek the death penalty on August 5th, 2021. The trial in this matter was originally set to begin on November 8th, 2021. The defendant waived his right to a speedy trial on August 20th, 21, and the trial was vacated. Okay? So this was initially the first trial date that was supposed to happen. He vacated it. The state originally had requested the trial be set in the fall of 2023. Okay, you see this? The state had originally requested this. But, here's the big but, right here. Here's the big but. But the defendant was adamant the matter proceed in January of 2023. So that's when they set January 9th, 2023. He was adamant, no, I don't want it in the fall of 2023. I want this in January 2023. Okay? So, on September 27th, 2022, the defendant filed a motion to continue the trial set to begin in January of 2023. The state did not object to the motion to continue based on the joint trial having been vacated in the defendant Vallow Daybell's case. However, the state's paramount position has consistently been this is one case for trial with the corresponding case for defendant Lori Vallow Daybell, Fremont County case, and they give the case number. The state has consistently opposed any improper severance and continues to hold that position. So what they did is they agreed to vacating January and set it for April because Lori had been being evaluated again, or her meds, reevaluated, whatever they had to do with Lori Vallow. We can't see any of that because it's under seal. So they set the trial date for April 3rd. That's the date we've got right now. April 3rd. It's April 3rd or April 8th. Let me just check so I'm giving you guys the right information. February, March, April. April 3rd, the trial is to start. But now John Pyre is saying, nope, 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 nope. Now I want it in October. Okay, you're going to see that coming up. When in fact, up here, the state originally requested a trial be set in the fall of 2023, but the defendant was adamant the matter proceed in January. So here we are, January. He vacated that hearing, that trial date, and it's now set for April 3rd. Okay, so defendant Lori Vallow had her initial appearance on May 26, 2021. Due to some pending competency proceedings, she wasn't arraigned until April 19th, 2022. And the state filed its notice to seek the death penalty on May 2nd. Defendant Lori Vallow did not waive her right to a speedy trial. Okay, so by law, they had to have her trial within a certain amount of time because she didn't waive her right. So hers was set for October of 2022. Okay. This date was later changed to January of 2023 to allow her trial to proceed with the defendant, Chad Daybell. New competency proceedings began regarding defendant Lori Vallow in September of 2022. And due to those proceedings, the January trial date was vacated. Defendant Lori Vallow Daybell has maintained she is not waiving speedy trial, and the joint trial was reset to begin April 3rd. If they do not go through now with this April 3rd hearing, trial, sorry, I keep saying hearing, there's going to be a problem, okay? The defendant Daybell has now filed another motion to continue the trial date set to begin in April. Okay, so this is Chad. They're not talking about Lori. They're talking about Chad. Okay, so now he's saying he doesn't want to go through on this April 3rd. I think he's trying to sever the trials. That's why they keep putting this out and changing the dates. Well, now that's not good. Now we want October. They can't put hers out a year. A year down the line for a speedy trial, she could end up walking. Okay. They could end up having to throw the charges out against her. Now, we do know that I showed you guys in the last update that she filed a defense. Did you guys all see that? If not, I will pull it up right now. She filed a defense. Did you guys see that? Let me know in chat before we continue. I gotta find it here. I can't see your chat right now, so I'm looking for this. For the copy of her. Oh, come on. Okay, here it is. Okay. Okay, have you guys all seen it? Okay, so let me show it to you quickly. It's just a couple of sentences. Okay, so this is what Lori filed on the 5th of January. Just so you guys know, okay? This is the notice of her alibi. And then we'll get back to why the state is objecting. So, because now she's saying she has an alibi, she was not involved in this, she has not waived her right to a speedy trial. If they push this past April, I do believe that her circus monkeys here, James Archibald and John Thomas, will file for a complete dismissal for a breach of her speedy right, her right to a speedy trial. Sorry, you guys. Okay, so this is what Lori filed with the court. Come now, the attorneys for the defendant, and pursuant to Idaho Criminal Rule 12.1 and Idaho 19.519, provide a notice of alibi as follows. Number one, Lori Vallow was in her own apartment in Rexburg, Idaho, when J.J. Vallow and Tylee Ryan died in the apartment of Alex Cox in Rexburg, Idaho. Defendant was with Melanie Gibb, David Warwick, and or Chad Daybell. Lori Vallow was in Hawaii when Tammy Daybell died at the home of Chad Daybell in Salem, Idaho. Defendant was with Melanie Bordeaux and or Audrey Barrentiero. However, don't come at me. Okay? So she's saying when Tammy died, she was in Hawaii with Melanie and Audrey. And when JJ and Tylee died, and she's saying they died in the apartment of Alex Cox, she was at her own apartment with Melanie Gibb, David Warwick, and Chad Daybell. So that's her defense. Okay, so let's go back to this. Thank you, Summer. Okay, so which brings us back to this. So the defendant, Chad Daybell, as we've seen up here, this is only regarding Chad Daybell, has now filed another motion to continue the trial date and set to begin in April. Defendant Daybell argues his defense team cannot reasonably be prepared for an April trial. Okay, you see that? Defendant Daybell argues his defense team cannot reasonably be prepared for April trial. But up here, the defendant waived his right to a speedy trial. Okay. The state originally had requested a trial date be set in the fall of 2023, but the defendant, Chad Daybell, was adamant the matter proceed in January. Okay. So, defendant argues his defense team cannot reasonably be prepared for an April trial. Yet you were adamant about wanting the January date, and April is well after January, and now you're saying you can't be prepared. Similar to the reasons he outlined in his prior motion from September of 2022. So now what he wants to do is he just wants to use his prior arguments and just throw that at them and say, well, I'm doing it for the same reasons I did back then. Well, we know what your reasons are, John Pryor. You want the trial severed. And what he's doing is he's doing everything humanly possible because they know Lori hasn't given up her right to a speedy trial. They know now they cannot continue to put this off. So the only reason that they can appease each one of them is to separate them. That's what he's trying to do in a backdoor way. Okay? So he's just going to use his motions that he filed to argue this yet again. Okay? And he's using that as to the reasons they were not going to be able to be prepared for a January trial. Well, this is a January trial that he was very adamant about getting. And, you know, the DA had already suggested the fall of 2023. And they said, absolutely not. We want our trial in January. So now he's saying he can't be prepared. But this is what he demanded. Like, it's like one hand doesn't know, like, what the other's doing, or he's got some kind of amnesia or short-term memory loss. I don't know. However, this is inconsistent with representations, I can't talk today, from counsel. Defendant Daybell's counsel represented at the hearing on the previous motion to continue, heard on October 13th, 2022, that he would be prepared for trial in January of 2023. Additionally, the defense has now had over 3 months from that last filing for a continuance to work on getting prepared for trial. Now, when he said that he would be ready in January of 2023, he knew about the death penalty. That's why they had to get the other lawyer involved, because John Pryor's not death penalty certified. They knew about all this for a year now. But now he's saying they're not prepared. Furthermore, as this court pointed out in recent order on defendant's objection to the court's scheduling order issued on December 16, 2022, The defendant mistakes the court's oh my gosh, whatever. In the October 28th, you got to forgive me today. I don't know why I'm tongue-tied today. I have no idea, but I am. In the October 28, 2022 order, as a concession that the defense is entitled to more time to prepare a defense. To be clear, the court's comments were a note that the Daybell's counsel had revealed it was not prepared to meet previously issued deadlines, and the comments were not intended to conclude Daybell had been denied ample time to prepare for trial. The record belies this very assertion. Oh, thank you, Diane, but I just cannot talk today. So if I skip over something or try to say something, these are common words to me. I don't know what the heck is going on, but anyway. There's no constitutional right or requirement for a mitigation expert. Oh boy, he's not trying to use this. Okay. So the defendant cites to his right to individualized sentencing, right to be free from cruel and unusual punishment, always taken from Lori's filings now, right to due process, right to a fair trial, right to the effective assistance of counsel, right to present a complete defense, right to a fair and reliable sentencing determination, and other rights safeguarded by the 5th, 6th, 8th, 14th Amendments to the United States Constitution and Article 1, Section 6, 7, 8, and 13 of the Idaho State Constitution. As one reason he should be granted a continuance. See defendant's motion to continue on page 3. However, the defendant fails to provide how any of these rights or provisions will be violated if he is not allowed a continuance to allow his mitigation specialist more time. Additionally, the defendant clearly acknowledges that the requirement for mitigation specialists is actually contained only in professional guidelines, which are not constitutional rights or guarantees. Oh, take a sip of my coffee. Maybe that'll help. I just woke up on the wrong side of things this morning. I'm telling you. You ever get like a moment where you know a word, but it just won't come to mind? Or you try and say something easy like spaghetti or something and you can't say it? That's my day today. It's been horrible. These basic duties neither exhaustively define the obligations of counsel nor form a checklist for judicial evaluation of attorney performance. In any case, presenting an ineffectiveness claim, the performance inquiry must be whether counsel's assistance was reasonable considering all the circumstances. Prevailing norms of practice as reflected in the American Bar Association standards and the like. Okay? So it goes on to explain here what the rights and guidelines are for them to have this, what is it they're asking for? A mitigation specialist. So it goes on. You guys can pause this later. This is 10 pages, so I want to get through this basically as quickly as we can to get on to the new evidence and everything that has come out. So they're just basically going over here that it's not a right. It's not a guarantee. It's not a constitutional right or guarantee that they can be given extra time for this. It is something that the defense can use as a tool or use as an expert witness to go over mitigating factors. It's not a right. So basically what they're saying is it has no bearance on this case. The defendant indicates he waited until August of 2022, and it's clear this decision was made knowing the trial was set to begin for January 2023. The defendant is now arguing the fact that he chose to delay obtaining a mitigation expert is not only grounds for a continuance, but would be a basis for the granting of a new trial if the court proceeds with the April trial date, which is complete BS. It doesn't fly here in Canada, and it doesn't fly in the US because it's not a constitutional right. So his constitutional rights are not being Denied. The state disagrees with this assessment. The decision not to obtain a mitigation specialist until August of 2022, when the defendant has known for at least a year, okay, since August 5th, 2021, when the state announced its intention to seek the death penalty, is just, oh my God, here we go. Strategic. I almost said strategic. This is my day. Welcome to it. Is a strategic decision left to the discretion of the defendant and his counsel. There is no constitutional right or obligation for a mitigation specialist to be obtained. The state does not disagree the defendant should be allowed to present mitigating evidence and is entitled to an individualized sentencing. However, none of the case law cited by the defendant references the requirement or need for a mitigation specialist, simply that the mitigation evidence is allowed and necessary. The distinction between the obligation to present relevant evidence in mitigation and hiring a particular staff person entitled mitigation special is exceptionally important. One is an obligation, the other an optional staffing choice. Oh yeah, so Judy, what they want is they want to, they're trying to get the trial separated. Oh, I've also got the stuff regarding Lori wanting to see Chad face to face and have this privy conversation. I want to see my husband in private. Oh, I'll get to that. It's coming too. The defendant cites, okay, they cite other cases where the mitigation special or mitigation expert has been applied. And none of this, like I said, I'll go slowly through this so you guys on the replay can watch this and read all through it if you want. I just want to get through this because there's 10 pages. They're just going over and they're citing cases where it was used, how it was used, and that it is not a factor in prolonging a trial date or vacating a trial date and continuing a trial date. And none of these that the circus on Chad Daybell's side, none of these that they cited gives them any grounds for and gives them no proof that it was ever allowed in the past, okay? And this is how it was used in the past, and none of them correspond with the case at the table right now. So you guys can scroll through this and read it on the replay if you want. Counsel in this matter has represented he's actively seeking out and obtaining evidence which he believes may be useful in mitigation if there is a penalty phase in this matter. Indeed, the record is replete with defense counsel's statements on his efforts for finding information helpful to the defendant. Counsel has represented the defendant for over 3 years regarding allegations which are part of this case. Presumably, given the length and nature of the representation, it would seem the defendant has had adequate time to consult with his counsel and provide him information necessary to obtain any relevant documents and evidence for use in the mitigation phase. Again, the defendant is simply basing the request for a continuance on the fact he decided, rather than gather mitigation documents through investigators or subpoenas, that they now want to add staff to the team labeled a mitigation specialist in August of 2022, several months before the trial. There is no evidence that Mr. Daybell's personal history is so complex or unique as to require a unique method or protracted period of record gathering, certainly none that could not be accomplished in the 8 months the specialist has been on the defense team. The defense motion does not include any reference to a particular type of evidence that the defendant needs to obtain through the specialist, which cannot or has not already been obtained in time before the trial. There's no evidence that Mr. Daybell's educational, social, mental health, or family records have not or cannot be obtained in time for use in trial in 3 months. Outstanding discovery, especially before the discovery deadline, is not a valid reason to continue the joint trial. Like, he's trying to do everything here, you guys, to get this trial separated. That's what he's trying to do. The defendant continues to harp on the outstanding discovery from the state and claims this is the reason for the continuance. However, the state has until February 23rd, 2023 to provide all discovery. Furthermore, the remedy for any outstanding discovery is not necessarily a continuance of a trial, but instead could include the exclusion of the evidence and or other remedies if appropriate or necessary. We've seen that in the Barry Morphew trial. The defendant is aware of the nature of outstanding discovery. It is, and we're going to get to that because there's new evidence that's come out. We will get to that. I've got a copy of that too and what it is. The defendant is aware of the nature of the outstanding discovery. So in other words, this new evidence that has come to light, the prosecution has let them know what it is, and they're aware of what it is. It is premature to conclude he will need an additional expert analyst or that it will take more than 3 months to complete such report, assessment, or evaluation. JDR, let's wait. We will get to that, okay? Let's just stay on topic here first. We are going to get to that, and we're going to discuss it when we get to that. I've got a bunch of them up top that we've got to get through. Furthermore, by far, the bulk of the discovery has been completed in this case. Again, the defendant relies on guidelines rather than any constitutional guarantees or potential violation of any constitutional right. The defendant also asserts, we're almost done this one, you guys, and we're going to get to it. They're not very long, the next one, so we will get to it. Additionally, the state has not continued to object to specific discovery requests from the defendant. The state has objected to the duplicative request with regard to items which have already been provided, some on multiple occasions, and also some that simply do not exist. So they keep saying that we didn't get this discovery from the prosecutor's office. Yes, you did. You got it more than once, but let's send it to you again. We've sent it now 3 times. They're trying to do this as a tactic to add to their claim that they need this mitigating specialist. And on top of that, we still don't have all the discovery, which they do. So they're just trying to compile as much as they can into this here as they can to try and maybe make the judge think, okay, well, maybe you do need it because you don't got all your discovery. Meanwhile, the circus has had it for over a year. Now, there is some new discovery. They have made the monkeys on the other side aware, on Chad Daybell's side, that yes, look at, we've come across some new evidence. We've got it. This is what it is. And this is what we plan to do. Now, as soon as we get anything back from that, you will have it right away. And we expect it. I know what the evidence is, and I don't think it would take more than 30 days for them to get anything back from that, which still gives them enough time for the April trial. It's in. Anyway, we'll get to that. Okay, so Lindsay signs this. So this one, it says 4 pages, but it's really not a lot. This is the response to the defendant's motion to declare Idaho's capital punishment scheme unconstitutional. So Lori filed this, and she filed this on the 12th of January. The defendant argues the prosecutors in this instant case have not narrowed the death penalty eligibility. Therefore, this court should declare the death penalty in this case to be unconstitutional. The defendant's death penalty challenge is not ripe. A claim is not ripe for adjudication if it rests upon contingent contingent future events that may not occur as anticipated or indeed may not occur at all. The Eighth Amendment claims of cruel and unusual punishment are not ripe when raised prior to the actual or immediately pending imposition of the challenge form of punishment. So this would not even come into effect, by the way I'm reading it, unless she's found guilty. Okay? Because the defendant has not yet been convicted. Okay, here we go. Because the defendant has not yet been convicted, any challenge to a potential sentence is premature. The state legislature has complied with the narrowing requirement that is set out by the U.S. Supreme Court, Capital punishment cases under the 8th Amendment address two different aspects of the capital decision-making process: the eligibility decision and the selection decision. Okay, so if you want to read all through this, they're just telling you what right means, what the two narrowing requirements are. And she is, after going through this, I've read it a couple times, she is death penalty qualified for the death penalty. So if you do want to read through all these sightings and everything else, you can. Okay, so the U.S. Supreme Court specifically ruled on the lack of a narrowing function when it denied a petition for a writ of certiorari in Hidalgo versus Arizona. The current precedent makes it clear that the legislature, oh my God, may satisfy the narrowing function in either of two ways. First, the legislature may itself narrow the definition of capital offenses. Second, the legislature may more broadly define capital offenses, but set forth by statute aggravating circumstances which would permit the jury at the penalty phase to make findings that will narrow the legislature's broad definition of the capital offense. So they're saying that they have complied with all of that. The defendant has cited to a law review article from a law professor that the aggravating circumstances in the aggravative do not functionally act as a narrowing requirement. So she's fighting that. This is a different case in Zant versus Stevens where case law has been set. She's saying that she falls under that category, but she does not. And that's what they're saying. So she doesn't fall under any of the categories that she has stated. Okay, so next, this is a few pages, but we're just going to skim through it like we did with the last one. This is Lori again. Objection to defendant's motion. This is Lindsay Blake now replying and saying they object to the defendant's motion to declare defendant not death eligible. Their argument is that the defendant has asked this court to declare her not eligible for the death penalty pursuant to the 8th, 14th Amendments to the United States Constitution. Her reasoning in this particular motion relies erroneously on the holdings in Edmond versus Florida. The defendant claims that the non-death eligibility of those convicted of felony murder who did not engage in the actual killing or intend that the killing should occur should be applied to her. Her motion must be denied as it's not right, which means it's not at that phase yet. And Idaho law allows the death penalty in this case. And 3, her motion has no basis in law or fact, but is instead an attempt to apply the felony murder intent rule to a premeditated murder and conspiracy murder. It's not ripe. We've just gone over that in the previous one. A claim is not ripe for adjudication if it rests upon contingent features, events, which this should not be here, may not occur as anticipated, or indeed may not occur at all. They're going through all what we just went through in the other one. So if you do want to read that through, you can, regarding the not right. Idaho law allows the death penalty for the charges of the defendant. First-degree murder is punishable by death in Idaho. Every person guilty of murder in the first degree shall be punished by death or by imprisonment for life, provided that a sentence of death shall not be imposed unless the prosecuting attorney filed written notice of intent to seek the death penalty as required under the provisions of Section 18-404A. Conspiracy is punishable to the same exact extent as the crimes to which the defendant has conspired. Idaho Code 18-1701 states, if 2 or more persons combine or conspire to commit any crime or offense prescribed by the laws of the state of Idaho, and 1 or more of such person does any act to affect the object of the combination or conspiracy, each shall be punishable upon conviction in the same manner and to the same extent as it provided under the laws of the state of Idaho for the punishment of the crime or offenses that each combine. So which that means, If you have conspired to do something, even though you're not there when the act is carried out and that person does it, you are held responsible as if you were there and did the act yourself. Now, you can also, where this act would apply, it's not saying it here, but there's another area where if you go with somebody on the intent to say, do a armed robbery, your intent may not be that I'm going there to kill anybody, but if a murder happens, well, in the act of another felony, you are also held responsible as if you pulled the trigger yourself, even if you didn't pull the trigger. Being there, being part of it, you are held just as responsible. So just tried to explain that a little bit. The defendant is charged with conspiracy to commit murder and premeditated murder. Upon conviction and upon a finding of aggravated factors by the jury, the defendant is death penalty eligible and as authorized by Idaho law. Neither the present case before the court nor the case of Chad Daybell involved felony murder charges. The attempt by the defendant to apply the Edmund and Tyson rulings in proverbial attempt to put a square peg in a round hole. They're on to her. The defendant has incorrectly relied on the felony murder rule because they're not charged with felony murder. They're charged with conspiracy to commit murder and first-degree murder, which is not felony murder. But they want to use the felony murder outlines to apply them to their case, which you can't do. They're two very separate and different charges. So the murder rule, providing that a defendant is not eligible for the death penalty when the defendant is only convicted of felony murder and did not engage in the actual physical killing. Well, that's different when you're charged with conspiracy to commit murder and first-degree murder. There's very different rules depending on what you are charged with, and she's trying to apply other rules to her charges, which they're not interchangeable. So that's what it's basically saying here. Rules that a defendant who is guilty of felony murder but did not commit the actual killing or did not intend for a killing to occur cannot receive the death penalty. As the defendant notes in her brief, in the Edmund case, court held that the punishment for a defendant must be tailored to his personal responsibility and moral guilt. But she's not charged with felony murder. She's charged with first-degree murder and conspiracy to commit murder. Totally different. But she's trying to use the felony. I already said this. Anyway, so this is just going over that. And it's here too. The defendant's attempt to create a two-pronged test the court never articulated or intended exposes the defendant's faulty application of the Edmund and Tyson in the case before the court. Felony murder is fundamentally different than premeditated murder or conspiracy to commit murder in that it requires no intent to kill, but arises out of a murder committed during the commission of another felony. That's what I just said earlier. Edmund is an example of a low-level participant who becomes liable for felony murder in that the defendant only intended for a robbery to occur, was the getaway driver, was not present when the murders occurred. If Edmund had intended that a murder take place as part of the robbery, premeditated murder or conspiracy to commit murder would have been appropriate, and the defendant would have been eligible for the death penalty, even if he hadn't committed the actual murder. So he just went there to drive them away. He had no part of going in, doing the robbery or the killings. So that's why he got a felony instead of a first degree and a conspiracy. But she's trying to apply those rules to her case. I don't know how her lawyers are doing this, especially in death penalty qualified lawyers. This would be thrown out like this is a joke. Like, why are you trying that? In further clarification on Edmund and the Tyson court held that an intent to kill was not required to justify the death penalty. Only a small minority of those jurisdictions imposing capital punishment for felony murder have objected to the possibility of capital sentence absent in an intent to kill, and we do not find this minority position constitutionally required. Okay, so this is why the conclusion, the defendant states in her motion, I should go a little bit slower there in case you guys want to read through that. It's just something that I just described to you guys and went over, but you can replay, gang. You can pause it and read that. The defendant states in her motions it's well established that the death penalty is reserved for the most egregious murders. She further quotes Gregg versus Georgia, stating the death penalty is reserved for crimes that are so grievous, an affront to humanity, that the only adequate response may be the penalty of death. The state concurs with these statements, and for this reason has filed notice of intent to seek the death penalty in this case before the court. The facts of this case are oh my God, can't say it now. Anyway, and heinous. The evidence the state will introduce at trial, some of which a grand jury has already reviewed, will establish that the defendant intended for her children and her boyfriend's wife to die, and that she affirmatively acted to make those deaths happen. The defendant has failed to provide authority whatsoever which would allow this court to apply rulings regarding felony murder to conspiracy to murder or first-degree murder. As such, the state respectfully requests that the court deny the defendant's motion. Oh my gosh. I need to untie this tongue. It seems when I try to slow down reading it, it gets worse. But today is just like lack of sleep, whatever. Okay, these circus monkeys again have filed, and this is very short, an objection. Now, who's filing this? Oh, Circus Monkeys for Chad Daybell has filed this. The prosecution filed a motion to have the jury sequestered from the start of the trial to the end of sentencing. Now, Circus Monkeys for Lori Vallow Daybell and for Chad Daybell. I didn't pull both of them up because they basically say the same thing, but they are objecting. Come now, attorneys for the defendant, and object to the state's motion to sequester the jury as follows. The defendant agrees that there has been extensive pretrial publicity in this case. Due to the court prohibiting cameras in the courtroom, the publicity has been moderated. If the court continues its order prohibiting cameras in the courtroom, then much of the sensationalism, got it out, couldn't say that just a minute ago, but anyway, of court proceedings can be prevented. Jurors should be instructed and questioned regarding their access to publicity, both during voir dire and during the trial. The jury trial should remain in Ada County and should not be moved back to Fremont County. If the jury is sequestered, the prosecutors will continue. So now they're guessing that the prosecutors will continue to seek the change of venue back to Fremont County. This motion to sequester the jury was filed on September 29, 2021, and the court granted the venue change on October 8, 2021. To hear this motion 16 months after it was filed is another way to continue the attack on the court's decision to transfer venue from Fremont County to Ada County. Both parties are entitled to a fair trial. For the jury to be sequestered away from their family, children, and homes for 2 months without phones and TV and internet would cause an undue burden on the jurors. If a conviction is rendered after the guilty phase portion of the trial, which necessitates the provisions of Idaho Code 1921-26, the jury must be sequestered at that time. The defense expects that sequestration would last 2 weeks for the punishment phase of the trial, as opposed to a 2-month sequestration of the guilt phase portion of the trial. So they don't want them sequestered. Next, this is just very short too. Second stipulation. This is again from the prosecution for consumptive testing. Okay, here is the new evidence. Lindsay Blake has filed this and given them both, Chad Daybell and Lori Vallow, an opportunity to probably see this and also let them know that it exists and that they would be transferring over the discovery as soon as they get the results back. The state, buying through the office of the prosecuting attorney for Fremont County and the defense, Chad Guy Daybell and Lori Noreen Vallow Daybell, through their respective counsel of record, hereby stipulate as follows. The parties agree that the hair samples recently discovered by the Idaho State Lab may be consumed by the state lab to determine if sufficient DNA is present to create a DNA profile. So what does that mean? That means that they have found hair samples from one of them, or maybe none of them, in evidence that they have. So this would have been when they got their search warrants and whatnot and collected all their evidence. Either somebody wanted the lab to go over another piece of evidence to try and find something, or they re-examined a piece. Something happened where they have now come across some hair samples. So what is that on? That could have been found on the duct tape that JJ's body was wrapped with. That could have been found in, I guess, the area where Tylee was buried. It could have been found in the area where they say the murders happened. They could have found these hair samples in the shed. Now, what I am thinking, and this is only my opinion, Lori is stating that she had no idea that this was happening. She was not involved in any way, shape, or form. When these murders happened, she claims to be elsewhere. Now, if they have found her hair in any of the dirt where Tylee was buried, I think they believe that at least one of the murders happened in that red shed on Chad's property. If her hair was found on tools or stuff like that there, or on the duct tape that was used to wrap JJ's body, she got a problem. She got a big problem. Okay. So they found hair somewhere. We don't know where. That was just my opinion, that it's one of those three places that they found it. Okay. That they feel that it's enough of evidence to include it in the trial. To me, I think for them to push for this at this late in the game, this is something that is important to prove that they both were there, or one was there. I believe it's going to have to do with the findings where Tylee was in that red shed, or where JJ was buried. Could be the duct tape. There's something there. There's something there that they have found that they think is important to include in this trial. Oh, yes, JDR. If Lori's hair, don't forget, we read her alibi, right? We read her alibi. Lori Vallow was in her own apartment in Rexburg when JJ Vallow and Tylee Ryan died in the apartment of Alex Cox in Rexburg. The defendant was with Melanie Gibb, Devick Warwick, and or Chad Daybell. Lori Vallow was in Hawaii when Tammy died. Okay? So, what she is saying is, there is no way you can say that I was involved in these murders because I wasn't there. I had no part of it. So, if they can link her hair to that duct tape, say there was some hair on the duct tape, say there was some hair when they were burying JJ's body, and some hair was found in that dirt there of hers, why would your dirt be 4 feet underground, Lori? If her hair was found amongst Tylee's remains, why is your hair below ground? If your hair is found in that shed where they believe Tylee could have been dismembered and burnt, set up to be burnt in the fire pit, why is your hair there? Could be on something they used to dismember or burn. Why is your hair there, Lori, if you weren't there? To me, if they find her hair underground, that's huge. That's huge. Why is your hair underground where your children's bodies were found, if that's where they found it, right? What do you guys think? think the hair has to include the hair follicle. Not necessarily. Not necessarily peas in a pod. Okay, so in the event sufficient DNA is available to create more than one profile, the DNA sample will be split between the parties for testing, and each party may have their expert of their choice test their respective portions of the DNA. In the event sufficient DNA is available for only one profile to be created, the parties agree the state lab shall halt any further testing, and the parties will reconvene at that time to determine who should conduct any further testing. Okay, so I want to know at this point what you guys think. Me personally, the biggest thing in this is where that hair was found. If that hair, this new hair that they've come across, don't forget, they took buckets and buckets and buckets of dirt, right? They also sift through all of that too. The dirt that's all around the bodies, they would take as evidence. If they found one of Lori Vallow's hairs there that came from underground, there is no way she can explain that away as to why her hair is there. Yeah, DNA testing is so far advanced now that they can get DNA from a hair without the follicle. And this is why I'm saying I'm anxious to see how much hair they got. I am thinking personally that this is maybe 1 or 2 hairs that they found. But the thing is where it was found. They don't say where it was found. Right? Because this is new. So if that hair was found underground or on that duct tape that wrapped JJ's body, or mixed in with the remains of Tylee, that's a big problem for Lori. Okay? What do you guys think? Because she's claiming, I had no knowledge of it. Yeah, there could also be fingerprints. I think those have already been tested and examined, but they are talking here, stay-at-home mom detective, that they found hair samples recently discovered. This is what they found, not fingerprints. They have recently found hair samples. Hair samples recently discovered, which means they have found somebody's hair within their evidence where that hair probably should not be. Yep, that's cool. Stay-at-home mom detective. The fingerprints are going to be big too. They may already have her fingerprints on something, right? I don't know if that discovery would have probably had to have been already sent over, but they're not letting us know about it yet. Peas in a pod, they can get DNA from your dead skin that falls off. You lose hundreds of hair every day normally. Like, this is just a normal thing. You lose skin cells at an alarming rate, but we never notice it. You know what I mean? Yeah, that's what I'm saying too, Sammy Smith. Please be Lori's hair. Please be found in one of those. To me, if I ever see something pop up in this that says, we found Lori's hair on one of those tools, in the blood in that red shed, or with either of those buried bodies, she's got a big problem. Because you cannot explain away how your hair is 4 feet underground wrapped with the bodies, or found with the bodies. Yes, it could be big. So, but we're not being told. Like, that's all we got. Oh, here we go. Sorry, there was one more here. In the event the state lab determines there is not sufficient DNA to create a DNA profile, the parties shall reconvene to determine what, if any, course of action to take regarding the samples. So these are newly found hair samples. Okay? This could be really big. Like I just said, we show it over here. Lori filed this on the 5th of January. Notice of alibi. Lori Vallow was in her own apartment in Rexburg, Idaho when JJ and Tylee Ryan died in the apartment of Alex Cox in Rexburg, Idaho. Now, if they died in the apartment, how do you know that? Right? How do you have knowledge of that? Number one is what I want to know. We haven't been told that yet. Could there have been things found in Alex's apartment? Absolutely. But she's saying that she was nowhere around when the children were killed. And her alibis are going to be Melanie Gibb and David Warwick and or Chad Daybell. And then she's claiming she was in Hawaii when Tammy died. She was. And she was constantly on, is she still there? Like, what's going on? Like, if you've seen any of the series that have come out, you'll know what I'm talking about with this. She was to meet Chad in Hawaii. And Chad was running late and this and that. And it was a Tammy thing and blah, 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 blah. And she says that she was with Melanie Bordeaux and Audrey. These are the court documents, JDR. Okay, so there has been recently, let me see, these are court documents. I get them right from the court thingamajig. Hair samples recently discovered, so this could be big. Okay, so response to defendant's motion for a joint settlement. Okay, so I told you, Lori made a motion that she wants to be able to meet with Chad face-to-face in a private room and have a private discussion with him where there's no lawyers present, not lawyers, no police or guards or anything like that, no prosecution from the prosecution side. They just want to have their little intimate powwow. And the reason they want to have this is they want to get their story straight. And I would never allow this to happen, okay? Now, there are reasons why the court would allow this. If there has been an offer of some kind of settlement, some kind of plea deal, something like that offered. To my knowledge, there has not been one offered. Now, like I said before, in all my stuff, you guys, I don't put anything in here that I cannot verify. I have seen no court documents where the prosecution is offering them a plea deal. None. Zero, zilch. Hasn't happened. I go by what the court documents say. Not, but there's a lot of people out there making up theories and this and that. No, there's a deal, and there's not. Believe me when I say it. There's not. So, with her wanting to have this little secret powwow where there's no recording of it, no nothing, she wants to have this little powwow. To me, they're trying to set up their stories to get their stories right. Look at, this is what we can do. We can pin it on Alex. This is how we're going to do it. Okay? So, response to defendant's motion for joint settlement and strategy session. That's what they are calling it. Now, the only reason that this would happen is if there was a plea deal, or if they were planning on accepting a plea jointly, or you admit to this and I'll admit to this and we'll take this deal. That could happen. But even then, it wouldn't go down the way Lori wants it to. Okay? So this is how the prosecution has responded to her little, I want to meet with my husband in private. Okay? State of Idaho, by and through Fremont County Prosecuting Attorney's Office, submits the following response to the defendant's motion for a joint settlement and strategy session. The state has serious reservations about allowing the co-defendants. This should be separated. Okay, hang on a sec, you guys. I keep getting this Now would be a good time to insert ads. No, it wouldn't. Sorry. No, bye. Okay, sorry. It just keeps popping up on my studio, you guys, to make you guys have to sit through ads and everything on the live. No, not doing it. There's enough in the replays. And we have no control over that. Anyway, okay. But I do have control over putting ads in here, and that's not happening. I appreciate you guys being here and your comments. And if you choose to make a donation, that's great. It's appreciated. Okay. So they want this joint settlement and strategy session, which I say the only way that this is generally used is when there's a plea deal being offered. The state has serious reservations about allowing the co-defendants to have face-to-face or other communication directly with each other. While the state recognizes that the defendants may communicate through their counsel and may strategize together through their attorneys, which the state would not be a party or have input on. There is no inherent right or privilege for the defendants to have direct communication. The state recognizes that the defendants have agreed to not use any evidence or information they may obtain through any discussions or meetings against each other. Nevertheless, the state is not willing to make a similar agreement. So what that means is no, although they may say, I'm not using anything you've said to me against you, and I appreciate you're not going to do the same because we're married and let's not sink each other. But the state doesn't have that agreement with them. If Lori says something to the effect of something Chad did, they are going to use that. That's why you have your fundamental right to remain silent, because anything you say can and will be used against you in a court of law. Okay? So any communication that they get via phone records, letters, anything, if they try and communicate with each other, the prosecution has a right to see or hear that. Okay? And they can use that against either one of them. So if Lori writes a letter to, say, Melanie, hey, Melanie, yeah, like, I know Chad was there, but they can't prove it, blah, 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 blah. Boom. They can use that. Right? Chad writes a letter to his kids. Hey, it was Lori's idea to kill your mom, and I didn't want to do it, but she was forcing. Boom. They can use it. Now, if they allow this to happen, where no cameras, no recording, nothing is used, no, the state is entitled to know what is being said. They are co-defendants, and that can be used against both of them or one of them. Okay, so any communications between each individual defendant and his or her attorney are confidential. However, having the other defendant and his or her counsel present would make them potential witnesses of statements made by the other defendant and eliminate any claim to attorney-client privilege. So what does that mean? If they have this powwow where they're not allowed to record it, and they're not allowed to have cameras, they're not allowed to have anybody from the DA's office in there, now the lawyers are now witnesses to what was said in that meeting. The prosecuting attorneys could call the lawyers as witnesses to those conversations. That is not client attorney privilege. Okay? And that's what they just said here. It eliminates any claim to client attorney privilege. In addition, the defendant is arguing there is a privilege pursuant to Idaho Rules of Evidence 408, 410, and 507. This is simply not the case. IRE 408 deals with statements made during a settlement or mediation negotiations, but without the state present, there can be no true settlement or mediation. This is where they would get together and say, look it, you guys are going to go down. We'll offer you the rest of your life in prison. We'll take death penalty off the table. That would be a settlement or a deal, as they call it, or mediation. Like, okay, I'm going to take all the blame for this, blah, 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 blah. So you get this and you get this. Like, that would be like trying to make a deal. You know what I mean? But without the state there, it's not a settlement or mediation negotiations. It can't be used. Regarding our IRE 410, since there is no plea being entered and no attorney for the prosecution proposed to be present for the discussion, this rule is not applicable. IRE 507 is applicable to mediations, but the rule does not necessarily protect statements made by co-defendants, especially to each other. In addition, the defendant is requesting to have a settlement conference separate from any mediation. What's further concern for the state is how a meeting would be facilitated, which would protect the confidential privilege of the defendant is claiming and also meet the safety concerns and guidelines, especially given the nature of the charges pending against them. Wherefore, the state respectfully requests the court consider the concerns raised by the state. And that's what they filed. So that's what we have. And again, the last one was just Lori's alibi. Okay. What do you guys think? I think in this position right now that Chad circus monkeys are trying to get this trial separated. Okay. This little powwow, in my opinion, could be, okay, Chad, I'm going to pretend that I'm right off the wall again and I'm going to delay it. But I don't want to delay it too much because then that's going to really mess with you trying to separate our trial. So what can I do? Can I demand, how about I demand my speedy trial and have my attorneys file for dismissal because you're going to try and have the trial vacated from April now, and now they're impeding on my rights. So how about we do that? You know what I mean? Like, get the hell out of here. Hello, Running Gray Wolf. And just to let you guys know, once the live ends, it will go private for some time, usually 15 to 20 minutes, while it's uploading to YouTube. I've had problems all morning trying to even get into my studio here, so I'm assuming it would take probably at least 20 minutes, but it could be shorter. And this will be up again for replay. So what do you guys think about what we just went over? Beach Bum says, maybe Lo needs a plunger for her portal. That explains it. Oh, yes, it does. It's a whole big mess. So for all you guys that are going to watch the replay, if you're just coming in now, just know that it will be private for about 20 minutes, maybe less, depending on how long it takes to upload to studio and for me to get my information in there. Yeah, they're not in JDR. They're not going to let them meet without the prosecutors being there. So let's stop screen sharing. Yeah, they're not going to let them meet. They're not going to let them meet without the prosecution being there. And I don't think they're going to allow this to happen anyway, because doing so with their lawyers there creates the potential of those lawyers now becoming witnesses for the state. So I don't see how they could be doing that. Yeah, the hair is very interesting. I want to know where it was found. Right? Yes, I agree. Marilyn, the thing is that I'm worried about is I'm sure that Lori and Chad are making plans through their lawyers. I think Chad is reluctant, and this is just my opinion. I think there's some that Chad is being reluctant on some things. That's why Lori is trying to push for this little secret powwow. so she can convince him by batting her eyelashes and I don't know. But I think they're trying to conspire together to have two separate trials. And what do they need to do to get that to happen? I do believe if they push this off again from April, that Lori's circus monkeys are going to file to have the case against her dismissed because she has not waived her right to a speedy trial. Her speedy trial should have happened on October to stay in line with the speedy trial rules. It didn't happen. They pushed it to January. January was vacated. It's now pushed to April. April, May, June, July, August, September, October. We're 6 months out from this being a year past her speedy rights. This could very well be dismissed against her. So, yeah, I hate that it takes so long too, Erna, but this is what happens when they know they're done. They know they're toasted Cheerios. You know what I mean? Like, don't worry about nobody peeing in your Cheerios, pissing in your Cheerios in the morning because your Cheerios are burnt crisp. Like, you're done. And I don't really think that the prosecution would offer a deal at this point. They got a slam dunk case in my opinion. I think that's reaching a bit. The lawyers would be there. I don't think they would be a party to that, and that would not happen there. They would still be watched through the glass. They just would not have cameras or recordings inside. If it goes to what Lori wants, they would still have a visual on them. Right. And that's why the trial, when they said, okay, well, we'll wait until January and we'll have this in January because she had another evaluation being done, blah, 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 blah. I think that's why they didn't really make a fuss about that one. But now that the January one, okay, they had to get her meds right or something. I don't know. That wasn't enough to say that her speedy trial couldn't happen because everything was back on track before the January 9th start court date. So she was back at the jail. She was ready to go for January 9th. It was Chad that put it out again. I do believe Lori agreed to that one. But that was it. Like April 3rd, let's go. If they try and do it again, Lori could very well, her circus monkeys could file to have the charges against her dismissed. Yeah, there's ways around that though. They could have their hand in front of their face, in front of their mouth, whatever, a piece of paper. They could have their backs to the wall that they're looking. They have to, for security reasons, they have to keep a visual on them. Whether that is a room with glass on one side so they can see into that room, but they can't hear whatever, there would be a way around that. But there's no way that even if this was for a settlement or anything, that they don't have a visual. They have to have a visual for security purposes. You're very welcome, Diane. Seeing Alex did, he'd have to have hair. Yeah, he didn't have any hair. Yeah, I think Lori's going to be up there. She ain't going to be having no baby. Where is that? Yeah, Lori is not going to be having no baby. Okay, so with that being said, you guys, I'm going to wrap it up. I wanted to make sure I got this out to you guys. I want to thank you for spending your hour and a half almost with me going over these documents, keeping you guys up to date. If anything else pops off in any of the cases, you guys know I will jump on here, go live, bring those documents to you as soon as I have them. Things have really calmed down, at least for me, in the true crime thing. So hopefully I'm getting onto some more of these reads. Okay. So with that being said, I want to thank each and every one of you for being here. Thank you, replayers. Thank you for being here. Like I said, this will be available again in about 15 to 20 minutes after the live ends. It takes about that long for it to upload to YouTube. Thank you, Sammy, for being here. Thank you, thank you, thank you, you guys. Thank you. Thanks to all of you being here. Oh, thank you, Running Gray Wolf. Okay, so with that being said, you guys, thank you, mods, for being here. You guys take care. I wish you a very happy rest of the day. It's about to snow again here, so I'll be sitting all toasty warm in my office here, getting going on some more of these readings. I got a bunch of private readings I got to catch up on. I'm far behind in them. I think I'm in the November, December maybe area of private read. So if you have emailed for a private read, we have not forgot about you. Okay. So until the next time, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.